Hello and welcome back to Newsroom Nigeria. This is where we give you hot, fresh, and sizzling news all day long. If you haven't subscribed to this channel, please make sure you subscribe. Turn on the post notification bell so that you can be the first person to get notified whenever we upload a new video. Help us grow this channel by giving this video a massive thumbs up so that it gets recommended to other YouTube viewers all around the world as well. Lastly, please leave your opinions and your comments in the comment section below. I love to respond to all of my comments, so keep them coming in. Let's discuss in the comment section. Without further ado, guys, let's delve right into the details of today's news. Breaking news: Atiku Abubakar receives heartbreaking news after applying to file fresh evidence against Tinubu at Supreme Court. Senior lawyer Paul Orokoro, a senior advocate of Nigeria, SAN, has emphasized that presenting supplementary evidence at the Supreme Court is a demanding endeavor that calls for extensive effort. He noted that the criteria for admitting new evidence at the Supreme Court are highly rigorous. Hirekoro made these remarks during an interview with the News Agency of Nigeria in Abuja on Sunday. He clarifies that, as a general rule, the Supreme Court tends to discourage the introduction of additional evidence. The general rule is that additional evidence at the Supreme Court or any court of appeal is not encouraged at all, but that doesn't mean that it is totally forbidden. However, the rules for admitting it are very stringent. The first is that such evidence is going to be extremely material to the resolution of the issues in the case. That's one of the hurdles to be crossed. The second hurdle is that such evidence could not have been procured during the trial at the trial court by reasonable diligence. So it is either the evidence was not available at the time of a trial, or it could not, by any kind of due diligence or any reasonable effort, be made available. For evidence to be admissible at the Supreme Court or in any court of appeal, it has to, at a very minimum, satisfied those two conditions, it said. When asked about the existence of constitutional provisions permitting a party to submit extra evidence at the highest court, the senior lawyer remarked, most of these rules are case laws and the Evidence Act does not specifically make these provisions. He stressed that it is only backed by the rules of a court. In the case of election petition, the Constitution requires that the proceeding be concluded within 180 days at the election tribunal, which in the case of a presidential election is the Court of Appeal. So the Court of Appeal, which may have the power to admit additional evidence, cannot have any jurisdiction if the jurisdiction of a trial court has expired. For instance, if a Court of Appeal has within 6 days to hear and conclude a presidential election matter and the 6 months have expired, even if the Supreme Court wanted to admit additional evidence, it doesn't seem to me that it would be able to admit such evidence after the expiration of the 6 months, he added. According to him, if such evidence becomes available, it is very likely that it cannot be admitted on trial. This is because it may not meet the jurisdictional requirement, which is that a court which has jurisdiction to do it will it have done it at this time, and if the period available for the trial court has expired, there is nothing the appeal court, in this case the Supreme Court, can do, he said. Orokoro explains that the Supreme Court, as well as any appellate court in the country, is mandated to address and resolve election cases within a span of 60 days. He clarifies that while the Supreme Court possesses the authority to hear the appeal, its jurisdiction extends solely to matters pertaining to the appeal itself. The fact that the Supreme Court has only 2 months within which to hear the appeal will not revive the jurisdiction of a trial court, he added. On whether there is a period within which a Supreme Court can admit additional evidence, Orokoro said, except when it is dealing with matters that have come before it under its original jurisdiction, the Supreme Court does not generally admit evidence. It is an appeal court, and its function is to see whether the matter was properly tried at the trial court and not to admit additional evidence. It's just that there are few exceptions to the rules regards that, and those exceptions I have already explained to you. But outside that, the Supreme Court generally does not like to admit additional evidence because it is not fair to the trial court, which did not hear that. 2, you will not give the other party the chance to maybe gather evidence that could have contradicted that. So that is why the rules are very strict, and that's why you don't see it happening all the time. He said though the move could succeed, he described it as an uphill task. When asked about grounds that an already decided case can be reviewed at the Supreme Court, he said though the grounds are not determined by law, there are rules of trial that are universal in Nigeria. One of them is whether due process was followed, admissible evidence rejected, or inadmissible evidence admitted. If a trial court failed to act fairly to both sides, if the lower court made a mistake as regards the law to be applied. So there are so many possibilities that the grounds of appeal can be built around, he said. Orokoro said though it was reported in the media that Alhaji Atiku Abubakar, the People's Democratic Party presidential candidate in the February 25 poll, planned to file new evidence at the Apex Court, it was still in the realm of speculation. This is actually within the realm of speculation because I have not seen the evidence beyond what the press has reported, and I don't know whether those who issued the document are prepared to come to court. Otherwise, there is a risk of what is called documentary ESA, he said. You all, let me have your thoughts in the comment section. What do you all think? Subscribe to this channel if you haven't. Give this video a massive thumbs up. It's looking as if at the moment Atiku Abubakar hasn't yet tendered another evidence, the latest evidence, which is coming from Chicago State University to the Supreme Court or the appeal court. So we are just, waiting to see the next move from Atiku Abubakar. It might just be deliberating and, thinking what his next move is going to be. But as for now, he hasn't, taken that step yet. Guys, thank you very much for always listening and watching. I will see you all in my next video. Bye for now.